Good afternoon, Judge Irwin. My name is Lisa Woodard, and I represent the defendant Pepsi. I'm here today to make a motion to vacate the default judgment on September 30th, 2009. Pursuant to the Federal Rules of Civil Procedure, the court may set aside a final judgment under Rule 60B. In discussing Rule 60 in Rogers v. Watt, the Ninth Circuit Court of Appeal stated the rule is to be liberally construed to effectuate the general purpose of seeing that cases are tried on their merits. Furthermore, Rule 60b-1 allows a party to vacate a judgment on a sufficient showing of excusable neglect or any other reason that justifies relief. In Pioneer v. Brunswick, the Supreme Court stated that the determination of what conduct constitutes excusable neglect under Rule 60b-1 is at bottom an equitable one, taking account of all relevant circumstances surrounding the party's omission. Guiding principles are 1, whether culpable conduct of the defendant led to the default, 2, whether the plaintiff will be prejudiced, and 3, whether the defendant has a meritorious defense. Your Honor, Pepsi affirms excusable neglect as a basis that justifies relief. Per Rule 60b-1, we assert, number 1, Pepsi's not culpable. Pepsi did not show intent to thwart these judicial proceedings, nor did it show reckless disregard for the effect of its conduct. Pepsi filed a motion to vacate the order and dismiss the claims on October 13th, as it wasn't even aware of the lawsuit until October 6th. The company had not responded to the April lawsuit until October because of a secretary's simple human error. 2, since the case has barely begun, the plaintiffs would not be harmed or prejudiced. 3, no default judgment can stand if the underlying complaint is defective. The plaintiff does not have a meritorious claim, and that there's no possibility the outcome of the suit after a full trial will mirror the results achieved by the default. There are 3 reasons the claim is not meritorious. First, the law requires very specific details about any allegedly misappropriated trade secret. All the 2 men claim is that they had an idea about a new soft drink and that Pepsi had used their confidential idea. Second, Pepsi began distributing Aquafina in 1994. The plaintiffs didn't file their lawsuit until 2009, well after the 6-year statute of limitations had closed. Third, when Pepsi failed to file a timely response, the men sought the billion-dollar judgment but never notified Pepsi of the amount damages as required. Your Honor, the judgment is unprecedented in size, and justice requires that Pepsi have a chance to defend itself. Wisconsin law disfavors default judgments, and justice is best served by overturning the prior ruling. Therefore, we respectfully request you properly grant this motion to set aside the judgment default. Thank you.